There is a type of regulatory instrument called the no-action letter. It appears in no statute you have read, and it has quietly governed trillions of dollars in market activity since 1972. No senator voted for it. No president signed it. One government employee writes it, and it becomes the framework corporations live by. What is it exactly? When a company wants to do something, issue a new financial product, structure a merger, exclude a shareholder vote from a proxy, but isn't sure whether that action violates securities law, they write to the Securities and Exchange Commission and ask. The SEC staff writes back. If the letter says the staff will take no action against the company for proceeding, the company proceeds. That letter is not a regulation. It is not a rule. It was never published in the Federal Register. No public comment period opened. No commissioner voted to approve it. It is a letter signed by a staff attorney, and it carries the practical force of law. How did this happen? In 1972, the SEC formalized a process that had been informal for years. Companies needed guidance. Staff gave it. The feedback loop became a system. The system became an institution. But it was never enacted. Not through the Administrative Procedure Act, not through notice and comment rulemaking, not through any mechanism that required public participation. Congress didn't authorize it explicitly, it simply accumulated. And as it grew, the letters began to define entire industries, mutual funds, derivatives, proxy voting procedures. The digital asset markets of the last decade were structured not around what securities law plainly said, but around what no-action letters implied. Law firms built entire practices around obtaining them. Billions of dollars moved based on their guidance. If you asked where the authority originated, the honest answer was nowhere you could point to in an enacted statute. The SEC staff decided. The market followed. And the market never looked back. Who controls it now? Not Congress. Not the commissioners in any meaningful real-time sense. The Division of Corporation Finance. The Division of Investment Management. Staff attorneys, some 2 years into the job, some 20. When a new administration arrives with a mandate to change regulatory direction, they cannot repeal no-action letters by executive order. They cannot rescind them through legislation because there is no legislation to rescind. They can issue new letters, but the old ones remain in circulation. A company that built its compliance structure around a 1998 no-action letter may still cite it in enforcement proceedings today. The letter persists unless staff explicitly withdraws it, and even withdrawal does not undo the economic architecture built in its shadow. Here is what this means for an ordinary person. You do not write to the SEC. Your retirement fund manager does. The firm managing your 401k assets sought a no-action letter decades ago permitting a specific fee structure and disclosure format. That letter was never a regulation. You were never a party to it. No public process produced it. But its terms shaped what your manager could charge, how your returns were calculated, what you were told about your own money. You did not vote on it. Your representative did not vote on it. And the fund manager who built their business model around that letter will cite it in court not as a rule they're bound by, but as evidence of the SEC's settled interpretive position, which courts frequently defer to under a doctrine called Skidmore deference, meaning an unelected staff opinion carries persuasive weight even over a judge's independent reading of the statute. Remember, no one voted for this. A staff attorney wrote a letter. Decades later, that letter is the load-bearing wall of a multi-trillion-dollar market. The lawyers and compliance officers inside that market know exactly what it is. They don't explain it publicly, because the explanation leads somewhere uncomfortable. And here is the part that should actually worry you: it's completely legal. You cannot repeal a no-action letter through legislation, because it was never legislation. You cannot challenge it under the Administrative Procedure Act the way you challenge a formal rule, because courts have held that no-action letters are explicitly not rules. You can ask the SEC to withdraw one, but the institutional memory of why it was issued is often decades gone, and the attorneys who wrote it have long since moved to the private sector, frequently to the very firms that relied on the letter. More critically, the economic structures built around it do not reverse when the letter does. An industry that spent 30 years operating inside an informal staff opinion does not reorganize because someone sends a withdrawal notice. The letter's power was never in the document. It was in the behavior the document licensed. And behavior at institutional scale does not unwind, which means every agency you have ever dealt with has a shadow framework running beneath its posted rules. Not the regulations on the website, not the laws your representatives passed. The actual operating system is letters, memoranda, informal guidance, staff opinions, documents that were never enacted, are not subject to repeal, and are legible only to the people paid to understand them. The SEC is not the exception. The FDA has equivalent mechanisms. So does the FTC. The IRS calls its version a private letter ruling. Every major regulatory body has built some version of this structure. The formal law is the public-facing architecture. The informal guidance network is how decisions actually get made. And the gap between those two things is where the real power lives. So here is what you are left with. If the rules that actually govern trillion-dollar markets were never voted on, cannot be meaningfully repealed, and are fully legible only to insiders, then the law you think you live under and the law that actually operates on you are not the same document. They never were. The question is what else runs exactly the same way.